Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have a packed agenda of issues which are worthy of discussion. I want to begin by welcoming all of our viewers who are joining us on television from region number 5, West Coast Berbice. Welcome to another program of Issues in the News. To our faithful viewers who are joining us on television in region 6, along the east bank of the Berbice River, New Amsterdam, Kanji, and all the way along the Quarantine Coast. Welcome to another program of Issues in the News. To our listeners and viewers who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us across Guyana on Facebook Live, across Guyana, the Caribbean, North America, Europe, and further afield, welcome to another program of Issues in the News. And please share this program, press that share button on your phone so that your friends and your followers can join us in tonight's discussion. I see faithfuls such as Madbar Singh, Sami Holford, Jiwan Kimraj, Moda Hansraj, Jack Deo, Alex German, Richard Stanislaus. Welcome, welcome, welcome. And please remember to put your comments in the comment section of the program so that we can have your views taken on board and discussed. If you wish me to answer any questions, please post them in the comment section. If you want to make an observation which you think is important and requires my input, then please put that in the comment section so that we can have an interactive program. So let's start. Viewers would recall that after the ruling of Justice Sandil Kisoon on the 3rd of May 2023, requiring, among other things, that Esso Petroleum and Production Guyana Limited lodge an unlimited parent guarantee, both the Environmental Protection Agency and the EEPGL filed appeals to the Court of Appeal against that ruling. The Attorney General was not a party to those proceedings. So the Attorney General was not a party to those proceedings in the High Court. However, on the 12th of May 2023, the AG filed a notice of motion to be added as a party to the appeals. On the 19th of December 2023, after submitting written submissions and oral submissions, the Court of Appeal dismissed the Attorney General's application to be added as a party. On the 31st of January 2024, the Attorney General appealed the decision of the Court of Appeal to the Caribbean Court of Justice. After hearing submissions from all parties, on the 13th of May 2024, that is today's date, not surprisingly, the Caribbean Court of Justice reversed and overruled the decision of the Court of Appeal by allowing the appeal and ordering the Attorney General to be added as a party to the appeal, which is still pending in the Court of Appeal. So once again, you see this decision of the Guyana Court of Appeal against the government being reversed by the Caribbean Court of Justice. I have made reference to a series of decisions involving the government in a particular type of case or cases, and the Court of Appeal consistently rules in a particular way, and the Caribbean Court of Justice consistently reverses the Guyana Court of Appeal. This is another example. Here it is that the government of Guyana is a party to a contract with Esso Petroleum, known as Exxon Mobil. We are a party to that contract. A High Court judge makes a particular ruling that can have the potential of bringing that contract to a halt. This is not an outsider. This is a party to the contract. That a court has ruled can come to a halt. One of the parties to the contract approaches the Court of Appeal after appeals have been filed and say to the Court of Appeal, look, I am a party to the contract. I must be heard. In addition, in our application to the Court of Appeal, we outlined the importance of this contract and the revenue generated from this contract to the developmental agenda of Guyana. We also explained in great details that the Attorney General represents the public good and the public's interest. This is one of the most important contracts ever executed in the history of this country, to which the government is a party, and from which the government is getting hundreds of millions of dollars annually, which the government is using to finance its budget and to execute transformational projects for the benefit of the citizens of this country. And that the Attorney General protects the public's interest in law. All those arguments are put forward to the Court of Appeal. And the Court of Appeal says, no, you cannot be a party. In fact, the Court of Appeal was bold enough to say that the Environmental Protection Agency can represent the government of Guyana in the appeal. The Environmental Protection Agency is not part of the government of Guyana. The Environmental Protection Agency is a regulatory body. It's an agency of state. In fact, the government and that agency cannot be seen to be working together, because that agency is the regulatory agency. It regulates both the government and the oil companies and operators in the oil and gas sector. By what principle of law or system of logic can the Environmental Protection Agency ever represent the interest of the government in a case? Excuse me. So, the Court of Appeal refused to add the Attorney General. So, persons out, any member of the public can file a case to stop a major operations in the country, and the government can't be heard. Any one of you, any citizen, has what is called locus standi to institute these proceedings, and the government respects that. However, when the government now goes to the court to join the proceedings, the government is told, no, you can't be heard. Although the government is a party to the contract, that is the subject of the case. And the government is to receive hundreds of millions of dollars in revenue that the government is using as budgetary support and to finance the country's developmental agenda. The Attorney General is the legal representative of the government. Yet, the Guyana Court of Appeal refuses to add the Attorney General. Fortunately, the Caribbean Court of Justice made short shrift of that ruling of the Court of Appeal and reversed it, making an order that the Attorney General be added to the appeal. You would also recall that in certain quarters in the press, they carried a series of articles saying that the Attorney General filed a secret appeal, that the Attorney General is siding with Exxon Mobil. No appeal was secretly filed. The appeal was filed in accordance with the rules for filing appeal. And the filing of that appeal cannot in any form or fashion be sensibly interpreted as siding or supporting Exxon Mobil. The government has an interest in ensuring that the oil and gas industry continues to operate because the government is drawing revenue from that industry. The government is using that revenue to fuel and finance its developmental agenda. Obviously, the government must be heard. And the government is not taking any sides. It is, as I said, it is the government that must determine, along with the Environmental Protection Agency, what is a satisfactory amount that should be lodged as the parent guarantee. And the government didn't come to this decision by itself. That is what the Environmental Protection Agency Act says. And that is what the license of the oil companies says. That this money that is to be lodged to the satisfaction of the government. And when I say so, I am being accused, and the government is being accused, of being in bed with Exxon. I have asked my personal assistant to send out the order of the Caribbean Court of Justice, which was delivered today. They said in that order that they will give their reasons in writing subsequently. But what was clear is that they did not hesitate to reverse the decision of the Court of Appeal. And they did it in a very summary manner because it was patently wrong. So I thought that I'll bring that to your attention because it is important. Many persons are asking whether we have received the written judgment of Justice Sandil Kisoon in the GTU case. As I'm speaking to you here tonight, we have not yet received that written ruling, although the judge said from the bench when he was delivering the judgment that we will get it shortly after. He read, from what I understand, was a prepared text. And he said so. And therefore, it ought not to take a long time. to make it available? Well, I believe it was delivered in April, on the 19th of April, and today is, what date? The 14th. 1 month has gone, and we are still to receive the judgment. I had planned to wait for the judgment to be delivered before I file my appeal. But since we are now running out of time, I will have to proceed to file my appeal and make my application for a stay. Of course, I will reserve the right to add further grounds to the appeal when the written judgment becomes available. That is a facility that is available to lawyers. But because there is a time frame within which appeals must be filed, I will not be able to wait until the expiration of that time. I have to file the appeal within the time frame, and that time frame is 6 weeks. 4 weeks have already expired, and we are yet to receive the judgment, which was described as a landmark judgment. Well, we are yet to receive it. Ronnie Singh, Keith Benjamin, Senator Ramdat, I continue to look at your comments. I continue to engage. So Gillian Lewis is asking, what is the next move by the government? The next move is that we will have to proceed with the filing of our appeal, and we will have to proceed with the filing of our stay of execution, because we can't wait any longer on the written judgment of the Court of Appeal, of the High Court. And you know, let me don't say more. But judges feel offended when they are criticized. I am only relating to you what the facts are. You will note that I am not adding, neither am I subtracting. I am not exaggerating, neither am I embellishing. I am imparting to you facts. If the Court of Appeal is ruling in a particular manner, in cases involving the government, I am disclosing that to you. And those decisions, when they reach the Caribbean Court of Justice, they are being reversed. I have the statistical data to establish that. I am not adding, neither am I minusing. I am not exaggerating, neither am I embellishing. I am reporting to you the facts as I understand them and as they are available to me. Today, I had the privilege of meeting with a large delegation from the New York City Police Department, the famous NYPD, led by Tanya Kinsella, First Deputy Commissioner of NYPD. Tanya informed me that she is from Guyanese heritage. Her mother is from Stanleyton, New Amsterdam. And she was Tanya Indrani Mohabir. She's now Tanya Kinsella. So I met with her and her delegation, and they left with me a number of insignia. This is from the NYPD Intelligence Division. They gave me NYPD and NYPD badge. They give me a lot of signage. These are keeps. I show you all of that because I want to remind you of the constant harangue to which I have been subject by that infamous lunatic in Brooklyn who regularly makes the allegation that I am wanted by the NYPD. He says that I'm wanted by the FBI, I am wanted by the CIA, I am wanted by the Homeland Security. And every time I go to New York or to the United States of America, I received excellent treatment by those very law enforcement agencies, or at least some of them. And here it is only today, an entire delegation from the NYPD met with me. Tomorrow, I'll put some of the photographs up on Facebook so that you can see for yourself. And as we were discussing, I raised the issue with them, jocularly of course. I advert their attention to this constant, ridiculous allegation that I'm wanted by NYPD, and I asked them whether I'm wanted. We had a good laugh, and they know the character well, and they said a lot of things about that character, which I will not divulge, as I have the greatest of respect for that institution, NYPD, and I would not want to breach their confidence. But I just wanted to share that in a light moment with you, so that you can, when you see that being posted, you can respond accordingly. I'm trying to go through the comments here to get your engagement. Anyhow, let's proceed. We have a number of important bills that we will be debating in the National Assembly this Friday. We passed a number of important bills last Thursday and last Friday, as we had two sittings in succession of the National Assembly. This Friday, we will be debating another important set of bills. We have stated, and I have stated repeatedly, that we are in the process of modernizing the legal architecture of our country, that the transformational developments that are taking place in our country cannot be accomplished without the legal framework. Almost every important sector in which we are pursuing these transformational projects require a statutory legislative framework, because it is that framework that will be the foundation upon which these projects are going to be constructed. And as we continue to transform, we have to aggressively put that framework in place. And then at the same time, we have to dismantle the archaic architecture of laws and replace them with modern legislation. So, in the commercial and legal arena of our country, like every other sector, we are experiencing a transformational change. As a result, we have to introduce new laws, we have to update our laws, and introduce new legal processes that are in keeping with the modern realities of today's commercial world. Against that backdrop, we have a number of important bills that I want to discuss with you this evening. So, we have an arbitration bill. Now, our arbitration law is, we have an arbitration act in Guyana that is, I think, 125 years old. That act was amended, I believe, twice, about 100 years ago. We are repealing that act, and we are introducing a new arbitration act. This arbitration bill, which will be debated Friday in the National Assembly, is perhaps the most modern expression of arbitration law in the Commonwealth, certainly in the Caribbean. Arbitration has long been recognized as the most preferred mode of settling commercial disputes. Gone are the days where huge companies want to go to court to resolve their disputes. They prefer alternative dispute resolution methods, and arbitration features prominently among those methods. At the level of the government, I review dozens of contracts weekly, multi-billion-dollar contracts. Every single one of them contains an arbitration clause. Meaning that if a dispute arises, the parties would like to settle that dispute by the mechanism of arbitration. In the private sector, no doubt, they are entering into contracts with similar clauses. And in almost all the contracts that I am reviewing, the arbitration is to take place in some metropolitan center outside of Guyana. So New York, Washington, Paris, London, Brussels, Hong Kong, you name it. The parties agree to take their dispute to those jurisdictions. Why? Because we do not have a modern arbitration legislation in place. Well, this bill is intended to change that. There is what is called a gold standard for arbitration globally. And it's a set of rules that was promulgated by the United Nations, and it is called the UNCITRAL rules. Our Arbitration Act embraces, our new arbitration bill, embraces those rules, and they are attached at the back of the bill as a schedule, so they apply. So that's the first point I want to make about the bill. Secondly, the bill, as I said, is a modern bill. It came out of a CARICOM model, but then I sent it to the US for the input of two of the largest law firms in the world, Arnold and Porter out of Washington, D.C., and Gibson and Dunn out of New York and London. These are two law firms that specialize in arbitration. They reviewed it and they made certain additions which we have incorporated. So, as I said, this bill is a very modern expression of arbitration law. It incorporates all the important and modern concepts available in the arbitration world. But most importantly, it allows for the establishment of arbitration centers in Guyana. So, a company that offers arbitration services in North America or in Europe can come to Guyana because we have the most modern law, and they can establish their arbitration centers here. And the very persons who would have been hearing the arbitration in one of the cities in the first world can now travel to Guyana and hear the arbitration right here. So we are creating employment, we are keeping millions of dollars, US dollars, within the shores of Guyana, and we are offering this multi-million US dollars facility in Guyana. So from every respect, this bill will have a fundamental impact in our litigation going forward and in the resolution of disputes, commercial disputes in particular. What is also a fundamental objective of this bill is quite apart from making Guyana self-sufficient in relation to arbitration and arbitration services. This bill is intended to make Guyana an attractive international destination for arbitration. We are an English-speaking country, so we have the entire South America that is not English-speaking, who can come here because most of the arbitration centers of the world are English-speaking. So they can come here to have their disputes resolved by arbitration. The rest of the Caribbean, of course, they can come to Guyana because we intend to attract world-class arbitrators. Latin America, they can also come to Guyana and do their arbitrations right here. So this bill is going to be a landmark change in our law. As I said, it is intended to keep arbitration of matters that needs arbitration interventions within the shores of our country. So that's the first bill, the arbitration bill. Then we have the criminal procedure, plea discussion, plea agreement, and the plea assistance bill. Let me read that back. The plea discussion, plea agreement, and assistance agreement bill. The criminal law procedure, plea discussion, plea agreement, and assistance agreement bill. Now, many of you looking at American television, or those of you who are joining us from the US and other countries, would know about plea bargaining. Plea bargaining allows for the prosecutor and the defendant or the accused person to work out a plea deal and to take that deal to the court and get the blessings of the court and dispose of the matter. The plea deal, all of that, this bill, brings in that into the legal system of our country, into the criminal justice system of our country. We know about the backlog in the criminal justice system. We know about the sloth in the system. We know about a heavy prison population. We know about the frustrations with a very slothful system. This plea bargaining law is intended to bring speed to the system, to bring efficiency to the system, and to save billions of dollars in judicial resources. It allows the prosecution and the accused person to sit and work out a deal. If the accused person wants to plead guilty, then that deal is entered into. But there are a number of safeguards. The victim interest has to be taken into account. The victim has to be heard. And the court has to conduct a particular inquiry. This plea bargaining can even take place before charges are instituted. And there's a significant development because you can have a number of persons charged or likely to be charged. And it's difficult, or it will be difficult to prove a case against all of them because there is no eyewitness. What this allows is for the prosecution to take one of them and give them a deal. Either a reduced sentence or some other concession. And then get that person to give evidence against the others. So you secure convictions. It saves a tremendous amount of time because if a man is given a deal, if he's to plead guilty and he knows that if he doesn't plead guilty, he can get 80 years in prison. If he pleads guilty, he can get a shorter period. This law allows all those discussions to take place. But it ensures that there is a fair and just regime of penalties. This is not intended to water down or to dilute the system of punishment for wrongdoers. It is to ensure that interest is served and that the victim is protected, the public interest is protected, public morality is maintained and protected, and the accused gets a fair deal. As I said, all plea deals must end up in the court. And the court will either object or adopt and ratify the deal. The statistics are clear. No other country in the world has used the plea bargaining mechanism more effectively and efficaciously than the United States of America. If you look at any of the television series dealing with law and order, CSI, Suits, you get a clear impression of how widespread plea bargaining is in the United States of America. The statistics that I looked at say that approximately 90% or more of criminal litigation is concluded by the use of plea bargaining mechanisms. So it is a tremendous success in the United Kingdom and certainly in the United States of America and across the Caribbean. Significantly, it is already in many of the countries in the Caribbean and across the Commonwealth. The Caribbean Court of Justice, when they visited Guyana last year, in meetings that I had with them and which the legal profession and the judges had with them, separated meetings, they emphasized the need for us to incorporate into our criminal justice system concepts such as plea bargaining. We are doing it in the most modern way now. And Friday, that is another bill that will be debated and hopefully passed. Another important bill that will be debated and passed is the Criminal Law Procedure Paper Committal Bill. This is another landmark piece of legislation in our criminal justice system. You know that there are certain types of offenses that must have a preliminary inquiry done in order to establish a prima facie case against the accused. And once that is established, then the case is sent to the High Court for the real trial to be held before a judge and jury. Those types of cases are the capital offenses cases. They include murder, manslaughter, rape, attempted murder, treason, etc. Those cases require, as I said, a preliminary inquiry to be done in the magistrate's court, and oral evidence is taken at that preliminary inquiry, and then the magistrate has to adjudicate upon that evidence to determine whether a prima facie case is made out, and if a prima facie case is made out, here that magistrate sends the case for trial before a high court. Now the preliminary inquiry takes 2, 3, 4 years. Most of the offenses, at least murder, the accused is remanded. So he spends 4 years in remand, and then after the case is sent to the High Court, he has to wait another few years before the trial comes up. So persons spend an inordinate amount of time in the criminal justice system and in prison. Countries across the globe have moved in the direction of abolishing the preliminary inquiries. England did it since 1967. The entire Caribbean has moved in this direction. In terms of sexual offenses, under the Sexual Offences Act, which we passed in 2009, in sexual offenses, there is no preliminary inquiry. So there is no preliminary inquiry in rape anymore since 2008. What happens instead is that all the statements from all the witnesses are filed with the magistrate, and the magistrate reads the statements, hears submissions from the defense and the prosecution, and then makes a determination. So there is no oral evidence lasting 2-3 years anymore. You look at the paper, look at the evidence on paper, the statements, and the magistrate makes that determination and either discharges the accused person if he feels that the case is not made out. If he feels that the case is made out for the accused to stand trial, then he sends it to the High Court. So that process now will be reduced from a couple of years to a couple of weeks. So a drastic reduction of time, right there, saving millions of dollars in resources and taxpayers' monies from every respect. Less time in jail, less people in jail, less time in the magistrate's court. There is no disadvantage. Sorry, there is no advantage keeping, rather, there is no disadvantage in abolishing the preliminary inquiries. The entire world has moved away from it. We are now moving in that direction. Of course, it has been challenged. Its legality has been challenged, both in Guyana under the Sexual Offences Act, as well as in the Caribbean. The Guyana Court of Appeal ruled that it's perfectly in order, that it is not unconstitutional, because persons were claiming, lawyers were challenging it on the ground that they lost their right to hear evidence in the magistrate court. They lost their right to cross-examine in the magistrate's court. And the courts that have adjudicated on this matter, both the Guyana Court of Appeal and the Privy Council, ruled that you don't have a right to cross-examine when that is not the trial. You have a right to cross-examine at the trial. And that right is maintained because your trial is not in the magistrate's court. Your trial is in the High Court. A preliminary inquiry is not a trial. So, this issue about the legality of paper committal has already been adjudicated upon and pronounced upon conclusively by the Privy Council and the Guyana Court of Appeal and perhaps the Caribbean Court of Justice. I'll have to check that out as well. So that's another important piece of legislation that we will be debating, Friday in the National Assembly. Another piece of important legislation that we will be debating would be the Fugitive Offenders Amendment Bill, Bill number 6 of 2024. Now, the Fugitive Offenders Act is the act or the law under which persons are extradited from Guyana to stand trial in a foreign state. Extradition law allows a country in which a criminal offense has been committed and where the person suspected or accused of committing that offense goes to another country. Extradition allows the country in which the offense occurred or took place to request from that country where the accused has gone to send that person back to the country where the offense was committed to stand trial for that offense. So, simply put, if a person commits an offense in the United States and is in Guyana, the US authorities can, using the extradition law, make a request in Guyana to the relevant authority to say, this gentleman, Mary Tom Jones, has committed a crime in my country and I want you to send him back and he will stand trial in my country for the offense that he has committed. And extradition is based upon reciprocity. So, where a person commits an offense in Guyana and is in the United States of America, we can make that request of the Americans and they will send that person back to stand trial in Guyana. Now, extradition law has a lot of procedure in it because it's a process that starts in one country and has to be completed in another. So you have to start the legal proceedings in the country where you intend to prosecute the accused person, and then come to Guyana and present a case in the Guyanese court if the person is in Guyana. And there have been great difficulties, technical difficulties, procedural difficulties in getting this done, because you have to bring court documents from one country, you have to get suitably qualified persons to come and bring the evidence in the other country's court and get that evidence admitted before the extraditing court in Guyana extradites. Over the years, that process has proven to be a difficult one and a very cumbersome one, resulting in the loss of many extradition cases because lawyers make a whole host of technical objections, and after a while, the cases are dismissed. This amendment is intended to simplify those rules and simplify those procedures. So once these amendments permit all the court documents in the country where the extradition has started, in the country where the crime is committed, and where they have begun the process of charging and going before a court to get the order to extradite the person who is in Guyana, all those documents are now going to be admitted in Guyanese courts for the purpose of the extradition. So a host of technical objections will now be removed, and extradition will be done very smoothly and swiftly. The U.S. Department of Justice has requested this amendment, and they have made this request in several countries in the Caribbean, including Jamaica in particular, where they were able to conclude successfully a number of extraditions which they were unable to do previously. These amendments made that a very comparatively simple task, and they were able to extradite a number of persons from the Caribbean, in particular from Jamaica. Guyana is now adjusting its laws to ensure that we have the same regime in our extradition laws as the other countries in the Caribbean, to bring us up to speed with the rest of the Caribbean. So, another important issue that I want to speak about is the fact that we were able to pass our ICC Cricket World Cup bill that would allow us to join the rest of the Caribbean in hosting the T20 World Cup, which is scheduled to start next month. That is the premier cricketing competition in the world. Tens of thousands of persons will be coming to Guyana. Millions possibly will be entering the Caribbean. We have 20 teams participating. It's a huge event. A lot of people are going to be here. Press, international press, support staff, players, coaches, and of course, fans. You know, you have countries such as India, Pakistan, Australia, England, Canada, etc. The fans follow the teams. So it's a mega event in the Caribbean, and we had to pass special legislation to allow that, to put in place a protective mechanism for the sponsors and the administrators of the tournament. Because, you know, they have a lot of intellectual property interest to protect. They have, it's a whole new regime that will govern the country for that period. It's only going to last a month. We have to collapse all the arrangements in respect of travels. So you don't have to get visa, work permit, and all these things. All of that are going to be collapsed. As I said in the parliament, we are to create one domestic space in the Caribbean. Then you have a whole host of security arrangements that have to be put in place to ensure that we meet the requisite standards fixed by the International Cricket Council. Because, as I said, this is a mega event and it's a multi-billion-dollar event. Millions of eyes are going to be on Guyana for this period and the Caribbean. Millions, if billions, not millions. India alone, once you're talking about India and Asia, you're talking about billions. We did also massive changes to our civil aviation laws to make Guyana a first-tier traveling destination for airlift travel. You know, you have to comply with all these international regulatory framework. And you have to put in your laws the required international requirements. We have done that with our Civil Aviation Act, and last Friday we passed the amendments. So Guyana should be a Tier 1 destination for air travel shortly, and that is what will make it so much easier for us to have more airlines, higher standing, and higher international ratings in the aviation arena of the globe. My operator is signaling to me that I have come to program time. I think that we have had a packed program. We dealt with some important issues, and I want to thank you very much for joining me this evening as we discussed